For third time. Hi, everyone. I'm Lesley Wexler. I'm a professor over at the law school. I feel like last year we really bummed everybody out. So I'm going to start with some good news this year. Then I will introduce the panelists, and then I will start asking some questions, and we'll leave some time at the end for those of you who are here in person or online, if you want to put it into the chat if you have questions for our speakers. So for some good news, the first is that the Biden administration is going to expand and strengthen HIPAA, which would mean that abortion patients' records would be remain confidential and would not be shared with law enforcement. It would protect patients, particularly who leave an anti-choice state to get abortion care in another state. This is a really important move because 19 Republican attorneys general tried to ensure that they would have access to these out-of-state abortion records, and the presidency is saying no. The second good news piece is that the EEOC provided some clarifications on the Pregnant Workers Fairness Act. Under the statute, employees with 15 or more workers have to grant pregnant workers requests for accommodations as long as they don't pose an undue hardship. So there were about 100,000 comments in response to this legislation, about 50,000 encouraging the agency to exclude abortion from the definition of pregnancy, and about 40,000 supporting its inclusion. And the EEOC ultimately determined that abortion is a condition for which workers can seek accommodations such as time off. Some other, I hate to sort of call them good news, but let's say moving back from the brink of bad news. So it looks like Arizona may successfully repeal the state's 1864 abortion ban. So the House Speaker had been blocking it, but it's looking like that we may see some action on that front. California is trying to pass legislation that would allow Arizona doctors to provide abortions in California, something they normally wouldn't be able to do in the interim period. There's a ballot initiative in Colorado that would enshrine abortion rights in the Constitution and the state's ban on public funds for abortion care. Reproductive rights groups in Indiana are making emergency contraception more available via vending machines. I wish I had more good news, but some is better than none. So with that, I'm going to introduce our speakers. So Ameri Klafeta is the director of Women's Women and Reproductive Rights Project for the ACLU of Illinois. In her role, she leads the legal team working to ensure broad access to comprehensive reproductive health care in Illinois. She's a key advisor to various stakeholders and advocates on law and policy in the post-Dobbs landscape. She helped lead the effort to draft and secure passage of the Illinois Reproductive Health Act, so we can talk more about what that act includes. She also assisted in drafting the 2023 Illinois Shield Law, protecting abortion and gender-affirming care in Illinois from attacks by hostile states. Before joining the ACLU of Illinois, she was in private practice litigating complex commercial matters in state and federal courts across the country. She received her law degree from the University of Chicago, and a coincidence at the exact same time that I was there, so we are classmates, and her undergraduate degree from the University of Michigan. Mike is the founder, volunteer pilot, and executive director at Elevated Access. Elevated Access uses volunteer pilots and airlines to provide free air transportation in support of people accessing abortion and gender-affirming care throughout the U.S. They do this work in coordination with over 100 partners around the country, including providers, care funding sources, and practical support organizations. Elevated Access came to reproductive justice through anti-racism, working to practice the principles of these ideas every day. Mike has been a pilot for more than 10 years with commercial pilot and flight instructor certificates And like the rest of Elevated Access's volunteer pilots, Mike donates his time and his personal funds to fly people from places where they cannot access the care they need to the places where they can. Elevated Access recently celebrated its second anniversary with nearly 1,200 flights totaling more than 580,000 miles completed by hundreds of pilots. And I just want to give a round of applause to the panelists who are out there doing this work every day. So the first question is for each of you, and just to tell us a little bit about what your work looks like on a day-to-day basis and how that work changed, if at all, after DOPS.
Sure, I can start. And first, let me just say thank you for inviting me back again this year. This was such a great event and such a great discussion last year, so I'm thrilled that Julie invited me back. So I've been at the ACLU of Illinois almost 6 years, and I joined in 2018. And pre-DOPS, a lot of our effort during that time period was focused on anticipating that Roe is going to be overturned and figuring out what we could do to safeguard rights here in Illinois. So we had very good law in Illinois at the time, but it was the result of a lot of court orders. And for about 5 or 6 years before Roe actually fell, we were engaged here in legislative efforts to shore up those rights and codify them in state law. Unfortunately, predicting what was to come and the importance of Illinois for people being able to access care. So pre-DOPS, there was a lot of work legislatively to codify Roe in the Reproductive Health Act and codify the ability to make all sorts of reproductive health care decisions without government interference, to expand Medicaid coverage for abortion care here in Illinois, to remove the old trigger language. That was the first thing that happened back in 2017, to get the old trigger language out of the books, and then repeal parental notice. So by the time the Dobbs decision actually came, we felt like we had Dobbs removed kind of the federal constitutional floor for abortion rights and was going to throw this back to the state. So we felt we had done what we could do here in Illinois to get us in a good position. Since the Dobbs decision, it has really been a roller coaster of trying to keep up, understand the legal landscape, and navigate it. That initial period after the decision was very chaotic from a legal perspective. Bans were coming into place, they were getting challenged, they were getting put on hold, they were coming back, all of which, has a direct impact on people trying to access care. So we were trying to navigate that. As the pace of the legal landscape changes, has slowed down, we've started to evolve into trying to track the broader picture of the landscape. So the mifepristone litigation that's before the Supreme Court that I'm sure we'll talk about. There's another case before the Supreme Court being heard tomorrow about emergency treatment provisions in federal law. Understanding those and taking a look at, now that we've more or less set the table here in Illinois, what can we do to build the wall up around Illinois to keep other states from trying to reach in here and interfere with the care that we're providing here? So that's kind of how it's shifted pre and post DOPS.
Yeah, so for myself, things have changed quite a bit because go back 2.5 years ago, about 6 months before DOPS, I had a 20-year IT career here at the university, and thought that's what I would be doing for another 10 years until I might retire. But I had this idea for this organization of volunteer pilots flying people to access abortion and to access gender affirming care that I thought would be something that I would do in my free time. And I still remember, and actually even back then when we first got the organization established, like Lesley said, we just had our 2-year anniversary, is that I thought that this would be something I did in my free time and maybe do more of later. And at the time, it was just myself and 2 other pilots. And I knew that we were going to need a lot more pilots than that, especially once the draft opinion leaked. And by the time the actual DOPS opinion came out, we had gone from the 3 pilots that it was to over 500 that were part of our network across the country. And we now have over 1,500 that will be part of our network. The thing I didn't expect to happen post-DOPS is I did not expect to have a career change. After effectively working 2 full-time jobs over the course of that summer immediately after DOPS, my immune system said, hey, you probably shouldn't do this. And I got COVID for the first time at an outdoor event, which tells you just how weak my immune system probably was at the time. And I said to the board, people have been, thanks to some viral social media, have been playing us with donations. I said to the board, I think I want to make a career change and have fun doing. So now here I am, about a year and a half into this, doing this work officially full time and getting paid for it. And so it's been a very big change. The thing that really brought me to this work from the anti-racism angle is that after so many deaths, murders of Black people by law enforcement and others, my wife and I have been trying to find something more that we could do because we're just tired that voting, protesting, donating just wasn't enough anymore. And thankfully, it was through that anti-racism framework that I found reproductive justice. And if not for that, I don't know if I would have had the thought to start this organization. So I'm really grateful that for those people that offer those kinds of workshops and had the opportunity to learn about reproductive justice, because now we've been able to help hundreds of people all over the country make sure that they get access to care.
So my next question is if you can, tell us maybe the most meaningful or a meaningful for Ameri, sort of a case or piece of legislation that you worked on, and for Mike, somebody that you helped access care, keeping in mind their confidentiality. But I think that it helps people when they can sort of point to specific individuals that they have helped, that it really helps, I think, continue to motivate the work. So whatever you can share would be great.
So just recently I did a flight for a woman that she lives in a state with a total abortion ban. She actually, when we were flying, we got to talking, and I don't ever ask people about what they're traveling for. In fact, I don't even know as a pilot what the purpose is of their journey, because it's not relevant to why we're flying them. But sometimes passengers do open up about their stories, and she shared with me that she actually, until she had a pregnancy that she didn't want to keep, she had no idea that abortion was banned in her state. And I think for a lot of people, if they aren't following the day-to-day news, aren't involved in politics, that they aren't aware of these things until it impacts them. And so she had reached out to actually her mother first for help, even though she didn't go into details, but she intimated that it was a result. Pregnancy was from an SA, and her mother was not willing to help her, get out of state to go get help. Thankfully, her sister was aware that organizations exist out there in the country to help people travel and get access to abortion, and as well as the funding and travel and everything else. And so she had reached out to one of our partners, who then sent the referral to us to fly her from where she was to a place where she could get access to abortion. That organization also provided her with housing, had a volunteer driver there in the airport to pick her up when they got there. I'm sure they helped her arrange funding and those kinds of things. And she said that it was just blew her away just how generous everybody is. Because I think people recognize that the system is cutting people out of something that is very fundamental to human existence, which is control over your own body. And everybody in this movement wants to do everything they can, everything they can afford to be able to help people that need assistance. And so she was the first, like many of our passengers, first airplane flights, not even on airlines or anything of that sort. She said, asked her how she was feeling. She said she was excited but nervous. And so, like I said, bad news, because it's like the roughest day airwise that I've flown. But and it was really bumpy. But after about 30 minutes, she got past the little spooks with every bounce of the turbulence. And we were just started casually talking about music we were into and everything else. That's when she told me the story and thing. So being able to help her get to her care, get back home safely and efficiently, as an example for people that are facing these challenges. I looked at what it would have taken her to drive if she had a car, and when she had a car to make the drive. It would have been 4 to 5 hours to make the drive, and I was able to fly her. And so, that makes a huge difference in people's lives, because they're not missing as much work, they're not away from the kids that they already have, like her case, all those kind of things. Lets them go get the care they need, get back home to their
I think there's a lot of the work that I do that really sticks with me all the time. The thing that I really carry with me is the work that we did around the parental notice of abortion law. So for 9 years in Illinois, we had a law that required young people who could to notify a parent of their decision to have an abortion, and if they couldn't, they had to go to court and ask a judge for a waiver of that requirement. And at the ACLU of Illinois, we operated a hotline so that they could call, and we would either represent them in court ourselves or connect them to a volunteer lawyer who would go to court with them. And in 2022, at the end of 2021, we repealed the parental notice of abortion law. It was effective in 2022. Just going to court. So I did a lot of work, supervising the operation of the hotline. I took hotline calls, but I also went to court with these young people. And I think, they're young people who, for whatever reason, couldn't notify a family member. We know that people who can do, young people who have a good family situation where they can notify a parent, they will. But these were young people who were not in safe homes, or for whatever reason couldn't notify a parent. And going to court, we would do the hearings in the judge's chamber. So it wasn't an open court, but they had to be in the chambers with me. Sometimes there was another attorney there, a guardian ad litem appointed to represent the young person, the judge, and a court reporter taking the transcript. And, I think most adults would be uncomfortable. And I mean, most adults would be nervous having to go sit down, talk to a judge about something that is really going to determine their fate and the course of their future, and to talk about really, really personal things. And I was just always so impressed by these young people. They knew it was right for them. They were very brave. They often had to overcome a lot of obstacles before COVID. They had to go to court in person. After COVID, we could do hearings over Zoom, but they had to find a quiet place to do a hearing where they wouldn't be discovered. They were trying to keep this from their parents because it wasn't safe. And so just sitting in the room with these young people, I've been in court with a lot of clients, a lot of corporate clients, but those are really personal, touching hearings when you hear young people talk about their future, what they want for their lives, and seeing them be able to make those decisions for themselves. And then the flip side of that is the effort to repeal parental notice. We're the only state to get a parental involvement law off the books. And we did it right before the Dobbs decision, when now obviously we're seeing a larger influx of patients in the state. But just seeing the effort that everybody put in all along the way, all the volunteers who worked with the young people, all the folks who called their legislators, who came out to town halls, the young people who came to tell stories and talk to legislators, just all of the effort to help what is already a very vulnerable group of young people.
All right, so I'm gonna get into some of the legal questions. So let's start with the Emergency Medical Treatment and Active Labor Act. So this is a federal law that requires hospitals to provide stabilizing treatment to patients who present to their emergency rooms. It preempts state abortion laws and requires that hospitals accept Medicare to provide abortion care when it is necessary to stabilize a patient's condition, even when this abortion care violates state law. So not surprisingly, states with bans are very opposed to this law. And so Idaho has brought suit saying that, well, I guess you tell us what Idaho is saying, sort of what you think the best arguments on each side are. If you want to do some tea leaf reading, that would be great. But if you don't, yeah, I'm very curious to hear what you think.
Yeah, so the Supreme Court is actually hearing arguments in this case tomorrow. So you may be seeing it in the news over the next couple of days. And the issue in this case, the issue before the court is really kind of a very particular legal issue, and it turns on the interpretation of this federal law and whether the federal law that requires patients to be stabilized preempts Idaho's abortion ban. So Idaho has a very broad abortion ban, and basically it's got some exceptions for rape and incest if there's a police report. But otherwise, the only exception is if an abortion is necessary to protect the patient's life. So if death is likely. then an abortion can be performed. The federal EMTALA law says that a patient needs to be stabilized before they can be transferred. The hospital accepts Medicare funds, so it's tied to Medicare funds. And it was originally passed, it was meant to protect against patients who may not have insurance from being kind of passed around or from hospital to hospital or decline of care in an emergency room. So that's why it says before a patient can be transferred from a hospital, they have to be stabilized. And that has to happen if it's necessary to protect the patient's life or health. So you can see that there's a scenario where a pregnant person comes to an emergency room. If a doctor is following federal law, then they may need to provide an abortion to stabilize the patient, not just to protect the patient's life, but also to protect the patient's health. That would put them at risk under Idaho's abortion ban, which says you have to really wait until, well, nobody knows what these exceptions in these abortion bans say because they're all so vague. But essentially you have to wait until the abortion is preventing imminent death. So that's where the tension is coming between these two laws. And the way this should work is the federal law should preempt the state law. But it's putting doctors in places like Idaho in the position of either providing care for the patient of what is probably standard of care treatment if an abortion is necessary to stabilize the patient versus, risking committing a felony under this law. So this lawsuit is between the state of Idaho and the United States government. The Department of Justice is enforcing the federal law. The anti-abortion advocates in this case are saying that this law doesn't say anything about abortion. It just says the patient needs to be stabilized. The law is not about abortion. It's about this, patient dumping, that's what they call it. And to the extent that the law does talk about pregnant people, it talks about, if somebody's in labor, transferring them in labor to protect either the pregnant person or the unborn baby. So the anti-abortion folks and the Idaho legislators are saying this is not a law of abortion. And if anything, the only mentions of pregnancy in here are about protecting the unborn baby. So that's where the tension is coming from. So there is a similar series of lawsuits proceeding in connection with the Texas abortion ban. In Texas, the courts have, in that litigation, which is going through federal courts in Texas, which are pretty conservative, as you all know, the courts have sided with Texas. In Idaho, the lower courts sided with the Department of Justice. And the Supreme Court stepped in. The Supreme Court accepted this case to hear, and that's what it's hearing tomorrow. And it also made the decision to let Idaho's abortion ban be in effect while the case is pending. So I think, we'll have a better sense tomorrow, maybe which way the justices are leaning. But to the extent, folks are looking for predictions about how this is going to come out, I don't know that it's a great sign that the court doesn't view, people being in life or death situations in Idaho or doctors being forced to choose between caring for their patients or going to jail as something, to hold off the cases proceeding. So that's what's happening with the Idaho case.
Can you talk to us about the Mifepristone case?
Yeah, so the other abortion case before the Supreme Court this term is a case regarding mifepristone, one of the two medications used in medication abortion. It's commonly used, it's very safe, it's been used for over 20 years in this country. Very, very safe. It was first approved by the FDA for abortion care in 2000, and that was after about 4 years of studies regarding its safety. And it has always been regulated more than other pharmaceutical products are regulated. It's always had more restrictions on it. Up until recently, you can't get it at a pharmacy. It's got to be dispensed from a certified prescriber. In 2016, the FDA loosened some of the restrictions on mifepristone. In 2019, it approved a generic version of mifepristone. And then one of the most significant restrictions on mifepristone was that it had to be dispensed in person, which ruled out telehealth and obviously was a barrier to people who could not get to a clinic to see a provider to pick it up. And during the pandemic, the FDA temporarily lifted, pursuant to court order, the in-person requirement. And then in 2021, it removed the in-person dispensing requirement completely. And that has been a game changer in terms of opening the door to telehealth for medication abortion. So a group of anti-abortion doctors brought a lawsuit in Texas in federal court against the FDA, challenging the FDA's initial approval of mifepristone and the FDA's loosening of restrictions in 2016 and 2021. Why did they go to federal court in Texas, of all places? They chose a district where they thought and were correct that they had a pretty good chance of a judge that would agree with them. If we were not living in these ongoing unprecedented times, this is not a lawsuit that I think anybody, looking kind of with a neutral view of the law would think would have legs. There are a whole host of issues in here. I'm going to talk about things to watch for. But one of that being, you can't sue in 2022 or 2023 about something that happened in the year 2000. Right out of the gate, this is not something that ordinarily would happen, and it is unprecedented to have a lawsuit where a group of basically concerned citizens are suing the FDA to withdraw approval for a drug. So this played out with a lot of kind of procedural back and forth in the courts in Texas. The initial judge who decided it agreed with the plaintiffs and said the FDA has to withdraw approval for this. It went up to the Fifth Circuit, they scaled that back. It went up to the Supreme Court, and the Supreme Court said, hey, stop, we're gonna hold up all of this. So this can keep going in Texas, but we're not gonna give effect to any of the orders. So none of these orders from Texas have taken effect. It went back to the Fifth Circuit, and they finally concluded, we're not going to go all the way back to the year 2000. They agreed that's too far back to go. But we will let these plaintiffs challenge the 2016 loosening of the restrictions and the 2021 loosening of the restrictions, including the in-person requirement. So that is the case that is going up to the Supreme Court. And the court heard arguments on that a couple of weeks ago on March 26th. So that is also. The other notable thing here is after these anti-abortion doctors filed their lawsuit in Texas, some blue states filed a lawsuit in federal court in Washington. And they said, look, FDA, if you're going to think about, making it more difficult to access anything related to mifepristone, we do not think you should do that. You need to keep the status quo because that affects the people in our states. So the same day, like 2 hours later, after this district court judge in Texas issued the order calling for everything to be, all of the approval of mifepristone basically to be withdrawn, a federal judge in Washington issued an order that said, FDA, you can't do anything to change the availability of mifepristone in these blue states, one of which was Illinois. And then eventually the Supreme Court did. So for a while we had competing court orders, and then the Supreme Court stepped in. So there are 3 issues to watch in this case. When we get a decision, I think the 3 issues you'll want to watch for. The first one is standing, whether these anti-abortion doctors in Texas have standing to bring this lawsuit in the first place. For the non-lawyers, standing just means when somebody files a lawsuit, you can't be a concerned citizen filing a lawsuit because you don't like something the government did. If you could do that, the ACLU would do nothing but file lawsuits all day, every day, right? To file a lawsuit and to get relief in a lawsuit, a plaintiff has to first be harmed, and they have to be injured in a way that is traceable to what the person they are suing did. So these plaintiffs are anti-abortion doctors. They don't prescribe mifepristone. They don't, they don't provide abortion care. The facts of the case are pretty shaky. Most of them not. Some of them are emergency room doctors, but most of them have not even seen a patient who's taken mifepristone. right? There's a dentist in there. They're just people who don't like, they're just people who don't like abortion. And if you kind of run the probabilities, you know, the chances that somebody has taken mifepristone, had a complication, are already pretty small, that has sent them to an emergency room, even smaller, where they may need an abortion to complete, you know, to be completed or something like that, or have some complication and end up before these doctors. That's a pretty attenuated change. And that is not a kind of standing that courts ordinarily recognize either. So these doctors switched their tactic and said, well, and that kind of harm is really unconnected from the FDA. Remember, it has to be connected to the defendant. So there's a lot of people in the chain between the FDA's approval of mifepristone and somebody showing up in an emergency room, including the people who actually make it, prescribe it, take it. The doctors kind of switched their course and said, well, we may, if people take mifepristone, we may have to treat them, and that would violate our conscience. We have a conscience objection. So that is where I think they're mostly resting now in terms of standing. In the oral arguments, you know, several of the justices seem to have a lot of questions about standing, and I think a lot of court watchers think that's kind of the easiest way to deal with this. I will also note that the lower court in Texas did allow some red states to intervene. In Texas, I think Kansas, Missouri, and one other. So it's possible if the Supreme Court gets rid of this and finds these plaintiffs don't have standing, this could continue with different plaintiffs who may have different grounds to assert. So that might not be the end of the story. If we get past standing, the other two issues to watch for, the second one is just courts versus the FDA. So the claims the plaintiffs are making here are really scientific about mifepristone, and the FDA studied it enough. Did they look? They're very particular. The FDA looked at certain studies. What was in those studies? Did they look at the studies cumulatively, or did they look at them one at a time? Courts are not suited to make these kinds of decisions. Judges are not scientific experts. These are decisions that you would ordinarily think should be made by regulatory experts. So it's already really unprecedented for this kind of issue to be before the courts anyway. And if they were to make some sort of ruling in this area, it could potentially have a lot of ramifications for other pharmaceutical products, things like, you know, vaccines, contraceptives, things like that. And then the last issue I'll mention just to watch for here is the role of the Federal Comstock Act. This is the 150-year-old anti-vice law. It's more or less a dead law on the books. If you were to just pick up the law book, it says, you know, you can't mail things that may be used in abortion. So if you were to just read that language in a book, the anti-abortion advocates say that says you can't prove mifepristone, you can't be mailing this because it might be used in an abortion in violation of the Comstock Act. In truth, this is kind of a dead law, and it's really not been interpreted that way. It's been interpreted and understood to prevent the meaning of things that would be used for an abortion, which is not the scenario that the plaintiffs here are trying to use it for. If there were a ruling on that, that would obviously have broad ramifications for all sorts of things used in abortion care. Justices Alito and Thomas sort of hinted with some questions around this. I wouldn't be surprised if necessarily if they wrote separately on the Comstock Act. I don't know that we would have a decision that gets any majority on the Comstock Act, but that's kind of the third issue out there to watch.
All right, I'm gonna switch over to Mike. How do your clients sort of learn about elevated access? So I would imagine, you know, for advocates, this is something that is sort of well known, but for someone who sort of unexpectedly finds themselves needing assistance, how does your organization get the word out, you know, in states that are increasingly making it difficult to not just access abortions, but to access information about access?
Yeah, so we work almost exclusively by referral for abortion work, and really there's a history to that. So when I first had the idea that pilots might be able to help. I didn't want to just white knight myself into a space, especially seeing that most of the people that are affected by abortion bans or restrictions are people of color and poor people. And so the issues that come along there are not things that I don't see as a middle class white person. And so I reached out to Midwest Access Coalition to see what volunteer work they might need, and spent a year volunteering with them doing security and privacy work and also talking about this idea of pilots helping. And when actually turned out to be a very pivotal step in terms of how we work, because if I had just started out by saying like, hey, I'm a pilot, I can fly people to access abortion, who is this white guy here, trying to do this work? Because no people watching online, but people in the room can certainly see there's not a lot of us guys, and definitely not much of us white guys that have to do this work. And so really by working with Midwest Coalition, when we started getting viral on social media, a lot of the organizations that are out there that are peers to Midwest Access Coalition, whether it's ARC Southeast, Access RJ, in California, or New River Abortion Success Fund, all these different organizations throughout the country, they asked Midwest Access Coalition, like, hey, is this for real? Have you heard about this? And they said, oh no, this is for real. It's one of our volunteers. And I think really that, those two things combined really showed that, coming at this from an ally approach and to join the movement was really the right way to go, because in that way, we don't have to get into decisions about which resources to use and whether it's a good use of resources. We don't have to confirm people's appointments or anything like that. We don't have to know why people are traveling, because our partner organizations, they've already called the clinic to confirm that they've got an appointment. They've already taken care of their ground transportation, their housing they might need, money for childcare, money for food, all those kinds of other support that we don't do. And so, really, that's we get the word out through our organizations, so that somebody who might need to travel to access an abortion or gender affirming care, ideally, is they don't come to us first. Really, we're just another place that's going to help them, just like a bus ticket or just like a hotel reservation that's being paid for by somebody else. We're just one more resource that the partner organization is providing.
Can you tell us anything about the risk that people working for elevated access or the organization itself faces, either legal, physical, or others? I think, for those of us who are a bit on the outside, as a lawyer, I worry about those things a lot. And so what are the risks, and what can you tell us about how to mitigate those risks, keeping in mind there are probably things that you don't want to tell us. That's fine.
Also, the first thing I always like to say to that question is everything we're doing in consultation with our lawyers, both lawyers' expertise in abortion and gender affirming care law, as well as lawyers' expertise in mediation law. Everything we do today, that does not mean that the state is going to come along and try to pass something that would make what we do illegal or restricted in some way, which is why we don't really talk about a lot of things. And so, for when it comes to like the staff and the team, we actually were recently targeted by online personality, and it was really the first test of do we have all the right security practices in place. And so as we continue to monitor the situation, we use in our organization, everybody uses a pseudonym for their last name on their public facing things, because again, it's not really relevant for me. I think it's also important for me as being the white guy in the room. I'm not doing this for notoriety. It's for the people that do this work. And so the side effect too, though, is that our opponents don't know who we are, can't harass us, things like that. And so, for the staff and for the volunteers, is it's basically a public underground organization, you could say. In that sense, is that we're very public about what we do, but we also try to protect everybody's privacy and anonymity as much as we can. When it comes to the way our process works, another reason why we work by referral that has some additional benefits is that, like I said, we don't know why somebody's coming to us to travel with us. And so, we tell our partners, one, don't tell us, but two, is it can be somebody they're transporting to an abortion. It could be a family member going to help somebody that maybe has had some complications and needs some extra support at home after their procedure. We provide transportation providers. Even for our partners, we've said, if you've got people that need to get to the state house, and they don't have a way to get across the state to go provide public testimony or something, let us know, we'll fly them too. And so all these things together, really make it possible for us to not only be aware, so maybe a passenger tells us, what they're traveling. But also when we work with our pilots, we also don't tell the pilots, one, why their person's traveling, because we don't know. We also don't tell the pilots what the partner organization is, because if we said it was New River Abortion Access, well, you'd probably make assumptions about that. And our pilots, they definitely understand, they definitely support that, is that it's really not relevant to why they're flying the person. They're there, they know what we do as an organization, they sign up to help people, that's what they're doing. And so all these things together, part of that strategy. The complicated part is really just trying to follow along with all the different things that are happening in all the different states. Thankfully, we do have this network of partners around the country that we can rely on because, for example, when Arizona's court case was made, we could ask our Arizona partners, like, how does this affect you? What can we do to help? And so that makes a big difference. And so, the work is definitely challenging that way. And, we do have the conversation in the team, in particular, probably towards me because I'm the more public facing side of things. That it's not a question of if, some attorney general or state attorney comes after us, it's probably more a matter of when. And so we're just hoping that we're prepared for that and we're doing things in all the right ways that hopefully you can get thrown out, but like our attorneys have told us, it will really just depend on what judge we get in front of, because if it's the wrong kind of judge, it won't matter how right we do things, that judge will come up with some excuse to find us in fault in some way, which is really it's maybe highlighting the reality of what the American justice system is for so many people, but now we see it affecting, a white guy. And I think it kind of just shows, what has been happening in the country for a long time, but even more so as judges have gotten more and more extreme.
So before I open it up to the audience, I wanted to see if the panelists had questions for each other.
I was going to throw Mike a question, if that's okay, and just ask. I know some of what we've heard from some of the folks we work with the abortion funds and others. They're very concerned now that Florida is going to have a 6-week ban. The Arizona opinion has gotten folks very nervous, and folks who are providing that kind of on-the-ground support. Do you anticipate an increase in services from those? And also, I'm wondering, have you seen a change in the folks you're transporting or the work that you're doing, kind of over the course of the 2 years?
Yeah, so in terms of where we see patterns, since we work by referral, it really depends on partner organizations, same as referrals, but as examples for what we do in this kind of situation with changing with Arizona and Florida is through our partner networks, as we actually had now starting about a week and a half ago, an ongoing call where we strategize with Florida partners and partners in destination states like Illinois and Virginia. What are we going to do? How can we work better together to make sure that the support goes as far as it can? Because even for us in a small plane, flying from Florida to Illinois, you're talking about 6 or 7 hours and hundreds of dollars to do that. And so we strategize with our partners about how can we make those dollars go as far as possible, combining those with airlines and support as well. But also the Florida ban in particular, less so with Arizona. Florida ban in particular is just partially about people in Florida. There are, I think that somebody said on the last call that there were more than 15 clinics providing abortion support, and easily half, not more, of people coming to Florida and getting abortions in Florida were coming from places like Georgia, Alabama, Mississippi, Louisiana, because that was the closest place. And so the impact on that is a lot bigger. So at least for the people that are outside Florida, maybe those airplane rides won't be as long. But it does just show that there's a lot of other trickle down effects. I haven't had a chance to talk to any of our providers here in Champaign. I don't know. I'm sure they're starting to talk about, okay, what are we going to do here in another 7 days when the Florida ban goes into effect and those kinds of things, because I'm sure there'll be surgeries and people come to places like it. I did a question for you actually. Is that okay? So you talked about a lot of these laws, we see the effects of people just think that things are illegal when they're not. So for example, Idaho has a ban on transporting minors without parental consent for abortion outside the state. When people most of the headline coverage was about just like, oh, you can't transport minors out of Idaho. No, it's more specific than that. But like when we see the legislation out there, are there any states, I think I know the answers, but are there any states that actually target the person that's getting the abortion? Because most of the legislation is about the providers.
I think there are 1 or 2 states that target the person, but for the most part, the states that have banned abortion target the folks who are providing abortion, or in some cases, they have language about aiding or abetting that brings in other folks who are assisting with abortion care. But you make a very good point about both the chilling effect, which is part of the design of all of this, and the misinformation, which is also part of the strategy of all of this. So even, we see it even when just bills get introduced, they don't go anywhere, nothing happens, but people don't know, they don't know until they need care often what laws are in place and what might be relevant. And for sure, the chilling effect and misinformation is all by design to deter people from not just getting care, but helping people get care, or providing care. One of the things that we did when we passed our SHIELD law here in Illinois last year, the SHIELD law is the law that we passed to make it very hard for other states to try to get information about people who had care here in Illinois, was to make sure that it was very broad and protects not just providers, not just patients, but all the folks who help them as well.
So we're going to open it up for questions from the audience. Julie has a handheld mic for anybody who would like to ask a question. Hi.
There was for sure creative argument, and it was definitely challenged. And I think again, this is a case of these plaintiffs forum shopping and finding a place where they could bring this lawsuit, where they would find a judge who is very favorable to their claims. So for a long time, with standing doctrines, for a long time, it's been recognized that abortion providers have standing to bring the claims on behalf of their patients. So a lot of times when the ACLU has brought litigation, it's abortion providers either suing in their own right because they might be subject to a restriction, or sometimes suing on behalf of their patients. So that is recognized doctrine, but that is different because they're providing care the patients want. They have a relationship with the patient, and it's very hard for pregnant people to bring their own claim in a timely way and get it before a court. What's also interesting is that there have been a lot of attempts to chip away at that. So some of the justices on the Supreme Court are very interested in taking away abortion provider standing. So at the same time that in the Kristen case, we see these plaintiffs given a lot of latitude for what are very speculative, hypothetical injuries. On the other hand, where we do have a close connection between the patient and the doctor, we're seeing the court try to weaken that and make it harder for those claims to be asserted.
Other questions?
Well, so one is, we have not been asked to apply a minor out of Idaho. But certainly our first question is there parental consent? Because that's what the law says. Anything more than that, I would say.
I'll add to that while Julie gets the mic over there. I'll add that there's a lot of litigation ongoing to try to clarify the rights of people, to help people travel, and to assist people in going out of state. So that's an area to keep watching in the courts to see how that develops and to define. We always have understood that you can do things somewhere else that you can't do in your own state. And so I think there's going to continue to be evolution in the law of that, trying to get clarity about their ability to travel. It always, these challenges always start with minors because that's kind of the easiest target. But I think you'll continue to see the courts give some direction there.
Okay, well, so that's pretty much harder for women, but also to get will they have standards? They have,
Well, so one of the things that we're seeing in Texas, you'll probably heard the case of Kate Cox that went through the news a while back, is we're seeing in Texas some of those stories of people who needed health care and couldn't get it. So that litigation is also ongoing. But, regarding people leaving, it's not just abortion providers who are leaving the states. Idaho has already seen a large migration of OB-GYNs leaving the state because it's just very hard to practice there in this environment. They don't think that they could do it. So those kind of ramifications will be ongoing.
Yeah, I'll say too that so coming at this from a reproductive justice lens, and as well as anti-racist lens, is that within reproductive justice, there's right to have children, right to not have children, control your own body or the future, raise children in safe and healthy environments. And I'm really grateful to have been brought into that movement because I was actually last year at UCRJ, one of the events that I met Isis Rose from BIPOC to Better Birth. And I was like, she was talking a little bit about the work she does. I'm like, wait a minute, would it be helpful if a pilot could fly you out to a community that maybe doesn't have midwives or other resources there? And she said, what do you mean? I said, well, I'm sure you have to drive and that kind of stuff. And she's like, ooh, actually, that sounds really interesting. And so we were actually, seeing, like you described, these deserts of care for obstetric care and care. Okay, we're hopefully before the end of this year going to be testing out working with midwives, probably first, especially midwives of color, and talking to them about the rural patients that they have and others, or if they're commuting between different places. What we can do to help, because it is a much, the impact of abortion bans go much beyond just restrictions on abortion. Because the doctors feel like they can care for their, high-risk patients, they're making choices, and I don't think they want to put themselves to, do I risk going to prison or do I risk my and I think they're making the choice to, well, I want to make ethical decisions, and they're going to go to somewhere where they can practice their benefits. So.
Personal efforts and concerns that get another identification of concerns and react. And you might want to speak about how, so I will say, right, reproductive justice is like all of us, right? These issues are all being individual.
Yeah, so getting to a place of recognition of fetal personhood has always been an end goal of the anti-abortion movements. And we see Alabama with the recent Alabama Supreme Court decision kind of getting there already and recognizing fetal rights around IVF. The two things that I think are interesting about that, one is the response in places like Illinois. So when we drafted our Reproductive Health Act, we were very clear, our law right there in the statute says a fetus, an embryo, or fertilized egg do not have independent rights under the laws of the state. But we've also over the last few years heard from a lot of lawmakers who have wanted to make sure that we're shoring up those protections. So there's, our law is very clear and protects assisted reproductive technologies. And, also in the state, it's one thing to have a right, another to be able to access it. And so there's been an effort to improve insurance coverage as well in that area. But the other thing is the public backlash to what happened in Alabama. I think that got a lot of people's attention in a way that a lot of other things didn't. And I think, abortion has always been othered. There's always a lot of stigma around abortion, siloed in medical care. It's something that a lot of people think is not relevant to them. But, we've always known, and it was very clear from the Dobbs decision that, the Dobbs decision wasn't just about abortion. It was about all of these other things. And I think that started to become more real for a lot of people when they saw that decision.
I think for people in the community, it's not really a lot of what I might possibly want to use this part of like later conversations that where liability is lost for something as sort of where like labor distances or and really outside of choosing to have an abortion and sort of what legislation looks like on that question a little bit the emergency laws. But I know there's a lot of legislation home in not able to get miscarriage or lawful pregnancy. And possibly what does that legislation versus
No, that's a great question. In blue states like Illinois, I mean, that's when we talk about abortion, there is a whole range of circumstances in which someone is having an abortion. And I think, again, a lot of people don't think, I have a lot of conversations, like a lot of regular people, my family and my neighbors who don't work in these spaces. And, a lot of people don't think about that, right, as abortion care. And I always want to be careful when I talk about it because, you don't want to suggest that one reason for having an abortion is any more valid than another reason. But I think a lot of people just don't think of that as abortion care, and it is. So our law here in Illinois and a lot of the blue state laws that protect this recognize that. And that's why you want to put the judgment with people and their doctors, and no two pregnancies are alike. People need to make these decisions, and particularly people who are carrying wanted pregnancies with complications need to be able to make these decisions with their doctors without the government interfering. Our law here in Illinois allows abortion up until viability, and after that to protect the life or health of the pregnant person. And health is more than just physical health. So our law is written, to contemplate some flexibility, understanding that no two pregnancies are the same. But our law also has a provision in it that says someone can't be punished for their conduct during pregnancy because of the outcome of pregnancy, which is a little bit different than some of the other blue state laws or excess state laws, which is intended to prevent this kind of criminalization of miscarriage.
I just wanted to quickly follow up on that. Can you tell us about, and I'm a little hazy here as to whether this is sort of demanded by law or whether this is just sort of an after effect of some of the pre-existing anti-abortion laws that you're hearing a lot of reports in situations like this of doctors performing C-sections as opposed to sort of more traditional D&Cs or other things that would be deemed abortion care, and sort of where is that coming from the law, or is that coming from somewhere else, and what efforts states are taking to push back on that to the extent that they are.
I think that a lot of that is driven by the fact that we are in uncharted territory. A lot of the protective laws that we have are novel. People who are in hostile states are concerned. And so I think, we see this in abortion care, but I think just generally people who work with pregnant patients, I think everybody has to make their own risk assessment. As Mike said, like, anybody can be sued for anything. And I think, there's just kind of a risk assessment. Some people have a greater tolerance. Some hospitals have a greater tolerance for risk than others. But I think it is a byproduct of all of the legislation and, again, interference of the government in the patient-doctor relationship.
And I have one more quick follow-up. I was wondering sort of where insurance companies fit into all of this, because I could imagine from their perspective, even if doctors or hospital boards or sort of people in charge have some risk tolerance, that's all predicated on having insurance and keeping insurance. And I can imagine insurance companies wanting to be not risk tolerant at all, because what benefit do they get out of being risk taking? And so whether we're seeing these decisions sort of being filtered through the lens of what does the insurance company want to do, as opposed to what does the doctor think is lawful, what does the legal team think is lawful.
A lot of later abortion care takes place in hospitals, particularly for people who are more medically complex. So Illinois actually started a program on their first anniversary. The Chicago area hospitals who are seeing medically complex patients, people by the time they get to Illinois, they're getting here later in pregnancy and sicker by the time they're able to travel. And so the Chicago area hospitals got a grant from the state to provide the CARLA program, so that there's one place that patients who are very sick and need complex care, who previously were trying to call different hospitals to figure out who could see them and when, and get that into a travel schedule. We call one place, they talk to a nurse, and the nurse coordinates with the hospitals to get them care. But, particularly, so in a place like Illinois, particularly when you have things in hospitals, there's different layers of administration. I think insurance may be a factor, and just kind of the risk tolerance of different institutions may be a factor. And then outside of Illinois, some of the banned states, they're back to, pre-Roe. You hear stories about the hospital panels, and people would have to go petition the hospital and go for a panel to justify their abortion. I think folks in some states are back to that. There's a story out of Tennessee, some doctor who was trying to get care for a very sick patient, and that had to go present. And you can't necessarily do that in a timely way, but I think insurance is probably part of it. And there's just, a lot of elements of risk.
So you started very much about breathing and acting. And so I was more we can talk a little bit about what people who have learning about this active could be doing to
So actually, this comes up somewhat regularly with the abandonment, is that people first, it does affect them, no matter what reproductive parts you have. These issues, whether it be abortion or gender affirming care, affects all of us. And so the next step of realizing that, like, okay, what can you do? Is we all have talents that we can put to work, and it's going to the organizations that are in the community, maybe in your region, your state, and national level, and tell them what you can do. And if they don't have a use for you at that time, go find another organization. And keep going until you find an organization that has a need for the skills you have. I can guarantee you there's something that you can do that is helpful. If it might be, working at a table in an event, or it might be helping to, maybe you're a lawyer, maybe it's helping to pull together some research to look at some law in their state, how an organization can operate in a way that's legal and stay out of the risk of that state. So no matter what it is, no matter who you are.
I know everybody is tired of being told that you have to vote, and I'm sure this group does not. I'm sure this group does not need to be told that. But I'm going to tell a quick story. I think last year when I was here, we made mention Danville, where they were trying to pass a sanctuary city ordinance. And the city of Danville was trying to exempt itself from the good state laws. And at the 11th hour, the ordinance passed, but they changed the language so that it would take effect. But that ordinance passed with, it was a tie in the city council, and it was the mayor of Danville who had to cast the deciding vote. And just weeks before, the mayor of Danville won re-election by a very, very small, I want to say it was like less than 100 votes, like a very small margin. So it is just super important. Like, I know everybody gets to the end of their ballot, the judges, whatever. But it is just very important to stay engaged. You can also sign up for action alerts. We do them at the ACLU, Planned Parenthood does them, Personal PAC does them. You can sign up for action alerts. When we send things out and say, please submit a witness slip, or, click this link to follow through and tell your state senator, this legislation is important to you. Like, we mean that. And if we do it, we really think it's going to make a difference. And so staying engaged on those things is super important, even in a state like Illinois.
So by function of where I went to law school, I feel compelled to say this one. It may be that your special skill is opening your wallet. These organizations need your money if you have it to give. And not everybody has it to give, and that's okay. But if you do, that is just as important. It facilitates everything else. And so sometimes that is my special skill, and I'm totally okay with it. And you should be too.
Thank you. Like this was planned. First of all, thank you so much to our panelists. Last year, we had a party for reproductive justice to end our first week. UCRJ week, we raised about $4,000. This year, our goal is $5,000. So there's a QR code outside, or please come to Rose Bowl on Sunday between 3 and 9 for a party. All of the money that we raise is going to be split between Elevated Access and Midwest Access Coalition, which is one of our regional abortion funds. That is one of the great ways. I also will encourage you to stick around for our next panel. This conversation is going to be continuing, talking about the legal landscape and how it applies to gender affirming care and trans rights. And one thing that really came up, I think, as an underlying theme here is the issue of the impact that this has on people doing the work to provide care, to provide travel, to provide getting on the phone, talking to people, helping them find where they can travel, how they can get the care that they need. So our first afternoon panel is actually people who are doing this work talking about the mental health impact it's had on them and how we can support them as well. I think we need to keep that in mind. And then I also encourage you that really struck me when Ameri was talking through the legal issues around mailing abortion funds. It's very current. And tonight at 7 o'clock, we're watching the documentary Plan C, which is actively on the ground following activists who were during the pandemic and after responding to how to get those resources to people. So it's very inspiring. So thank you so much for being here, and we will see you at the next panel. Thank you. area around issues of reproductive justice, which, just to remind everybody, is the right to have children, the right not to have children, and then the right to have families in safe and healthy. So I'm very thankful to the sponsors who helped us make this week and today happen. Of course, Spurlock Museum for giving us this beautiful auditorium to use for our panels today. I'm grateful to University Library, who is allowing us this year to live stream and record this panel. So that, thank you, Sarah and Sarah there. I'm also grateful for the support from ACLU of Champaign County, Elevated Access, McKinley Foundation, the School of Social Work, and the Unitarian Universalist Church of Urbana-Champaign. I'm also thankful to my steering committee who helped us make this possible. Earlier, our first panel of the day was talking about the legal landscape as it relates to abortion and abortion access. It's a topic that could have taken much more time to talk about, but I hope that it was a good primer for people to understand the very fast changing landscape of issues. We're really excited for this panel now to then give us a brief insight into the legal landscape as it relates to gender affirming care and trans rights, which we know are very related. So I know we're going to hear how the tactics that are being used are similar, but the effects that they have on our community are unique. And so I'm really excited that we could have this panel today. We have Tavish McMillan back this year. Tavish was a panelist last year and is helping us moderate today. Tavish has over 10 years of experience working in reproductive and LGBTQ+ health, from being a director of behavioral health policy and strategy at Howard Brown Health to currently serving as a senior paralegal for Planned Parenthood Illinois. Tavish earned her bachelor's degree in behavioral science from
National Literacy.
Thank you very much. My mentor. Then completed her master's in jurisprudence and health law from Loyola University Chicago School of Law in 2021. Currently, Tavish serves as a chief policy advisor for the Institute of Racial and Cultural Healing, while also being a senior consultant for human resources and DE&I for MYSI Corp, a nonprofit helping displaced youth and families across the planet. And then our panelists this morning, Brian C. Johnson has served as the CEO of Equality Illinois, the statewide LGBTQ civil rights organization, since 2016. In this role, he leads efforts to build a better Illinois by advancing equal treatment and full acceptance of the LGBTQ community. Prior to his time at Equality Illinois, Brian spent nearly 2 decades as a leader in social justice. His passion for fighting for equity was catalyzed, having served as a first grade teacher and Teach for America Corps member in Baton Rouge, Louisiana. Brian came to Equality Illinois from Leadership for Educational Equity, where he served as the Vice President of Regional. In this role, he helped lead the nationwide efforts to recruit nearly 300 teachers and former teachers to become candidates for public office, while simultaneously launching community-led organizing efforts in a dozen cities across the country, including Chicago, New York, Houston, San Francisco, and LA. Brian earned his AB magna cum laude from, is it laude? From University, his JD from Stanford Law School, and his MBA as an R.J. Miller Scholar from the Stanford Graduate School of Business. He lives with his husband Toby and their daughter Josie in the Lincoln Square neighborhood of Chicago. So glad that you're here. And Ameri Klafeta is back with us, and she is the director of the Women's and Reproductive Rights Project for the ACLU. In her role, she leads the legal team working to ensure broad access to comprehensive reproductive health care in Illinois. Ameri is a key advisor to various stakeholders, advocates on law and policy in the post-Dobbs landscape. She helped lead the effort to draft and secure passage of the Illinois Reproductive Health Act. She also assisted in drafting the 2023 Illinois Shield Law, protecting abortion and gender-affirming care in Illinois from attacks by hostile states. Before joining the ACLU of Illinois,
Ameri was in private practice, litigating complex commercial matters in state and federal courts across the country. She received her law degree from the University of Chicago and her undergraduate degree from the University of Michigan. Please join me in welcoming. You are all amazing. Thanks so much for being here. I'm going to take a seat in the audience and I'll invite Tavish to go ahead and start.
Absolutely. Thank you so much, Julie, for having us, and also everybody out there. Thank you so much. It's a pleasure being here. You know, I wouldn't be a legal professional if I didn't have a disclaimer, so I'd like to do that really quickly.
Hey, that's very tough.
Thank you. I want to make everybody comfortable. One, I am not an attorney. I am not licensed in this state or any other state. I studied jurisprudence, which is the theory of law, and how it intersects with society, cultural, and also political spheres. So anything I say is not, please do not take it as legal advice. Okay. Can't speak for the rest of the panelists, but I need to say that. Second thing is that while Planned Parenthood is incredibly happy that I'm here, I am not speaking on their behalf. I am speaking for Tavish. With that, do y'all have any legal disclaimers? For the best.
I don't think anybody up here is giving you legal advice.
So, you know, the thing that I really wanted us to focus on, based on, you know, not only the questions that we all submitted, but also just kind of the landscape that's going on at the moment is, you know, what is it that Illinois has done, is doing? And I know that all of us are very connected to things that are going on in Illinois. So I thought that we might start with that. By all means.
So I'm going to start and say, after the Dobbs decision, when we went back to the legislature, back to policymakers to sit down to look at what does this mean and what can we do to protect everybody in Illinois, it was very important at the ACLU of Illinois that we were focusing not just on abortion care, but also gender affirming care. We knew from the get-go, we knew all along that these two things were going to be connected. And so in all of our policy work since then, most importantly, passing the SHIELD legislation last year to keep other states from coming in to try to attack people providing care, helping get care in this state. We wanted to make sure that all of these efforts have been focused on abortion care and not leaving anybody behind, including folks providing, seeking, helping people get gender.
Love to build on that, but first, let me do some thank you. So it is just such a treat to be here. Thank you for having me. I want to thank the United Pride team for connecting me and bringing me down. And to our moderator, I know you're here on your personal time, Tavish, but I will say there are few institutions that are ally-like greater champions of queer people than Planned Parenthood.
Thank you.
So thank you. And you know, Ameri, I know with your work at ACLU of Illinois, there are a few people who have made our legislation stronger and better, not just for pregnant people, but also for queer people. So thank you. You know, I think just building off of what Ameri said, you know, after Dobbs came down, we at Equality Illinois put together a lecture and went to every legislator, we went to the Attorney General, to the Governor's office, and we said, gender affirming care and queer rights and reproductive freedom rely on the same frameworks. These are not separate issues. They manifest distinctly. Their impacts are felt different, but they are at their core fundamentally about the legal right to form our relationships and things as we see fit, the legal right to our own bodily autonomy without having to parents. Those are the two key things. And you know, going all the way back to the Griswold decision, 1965, you know, which said we can't have laws that criminalize contraception. That, you know, at the root of both of these is the fundamental privacy right to do with our own methods and form our own relationships and be fit. So we like to say that equality, you can't clean just your own section of the pool. And that's because they're very different things. But the other reason is because the other side views the message. right? They're coming out, they're sitting back and saying, who are the most vulnerable in this coalition? Disproportionately trans young kids, Black and brown trans folks. Who are the most vulnerable? If we can go after them and start peeling back those rights, then that is like the most intent. If we can get good policy and good law, or what we would say is bad policy, you know, to say that those rights don't exist, then we can start chipping away at rights that are broader swath of people in our nation. And so helping legislators and key decision makers to understand was central. I think the final thing that I'll say is that, you know, one of the things that we've insisted on with our coalition partners is that we have to stay in office. And if there's only one thing, I hope there's a lot that we've learned from the fall of Roe, is that if as a sector we situate ourselves in a defensive posture, we allow the other side to determine the agenda, figure out, use their money, resources, and time to figure out how to come to us. And one of the best ways that we can fight back on this is to say, we are okay just forming a baseline called, you know, 2020, and saying that that's the position we want to hold on. We have to keep moving the ball forward, in part because queer people, pregnant people, people who can become pregnant women deserve greater equality and recognition for our collective dignity, but also because the more that we are staying in offense, the more the other side has to respond to us. And over time, I can talk about what that means, but that is a central organizing principle, right? 2020 was not enough justice, right? Going forward.
Well, there's no time like the present. So to your point, I would just like to add that this is not meant to be a dig towards our legal community or also even the state of Illinois or any court, you know, decisions that have been made. But I just want to add, you know, the thing is, when it comes to an office, it's not about only a court. It is about advocacy. It's about going and speaking to these politicians. It's about, you know, many other things. And I think one of, if I dare say, one of our perhaps misconceptions, mistakes, blind spots was relying too heavily that the court was going to continue to uphold our, you know, reproductive rights. So, you know, with that being said, thank you so much to Equality Illinois. Also, you know, one of the things I will say, and I know that I can get away with this, my general counsel won't be mad at me, is I know that Planned Parenthood absolutely, you know, tried to do its best to prepare for the fall of Dobbs by really investing in trying to open up more clinics, especially around the border. I know that we recently opened up one, Carbondale, for instance. I know, so happy about that. And so, you know, there's definitely a lot that needs to be done, but there was a lot that was done. For those of you that were a part of it, thank you so much. Seriously. Now, you brought up similarities, and I think that's great. And there are so many similarities between reproductive rights and trans rights / gender care. But I would really like us to maybe just take a moment and think about the differences. Shall we go in the same order? That's okay. Okay.
So from a legal perspective, when trying to think about policy and law for abortion as compared to gender affirming care, one of the key differences, especially for people who are, you know, basically refugees from their home state coming here for care, someone may come here for abortion care and they will get an abortion and they will go back home. They may have a medication abortion and they may go home and it may complete there, but it's going to be a relatively discrete period of time. Gender affirming care is not necessarily going to be the same way, and it may continue. There may be multiple visits. It may take a lot of different shapes and forms. I think another, so, you know, when trying to think about what can we do to strengthen protections here and protect the people involved in seeking and providing care, keeping in mind the ways that this presents differently. I think another element is with respect to abortion care, it's always been siloed from other reproductive health care. You've always gone to the clinic, it's somewhere else. The community has developed around that. Gender affirming care is a lot, where the definition is a lot broader, the types of care are a lot broader, the types of places it may be provided are a lot broader. It could be, you know, counseling that somebody does a small office in their house. It could be surgery that's provided in a hospital. So in trying to think through how we kind of respond to the moment of challenges, you also have to take into account that this is going to present in a very different way with folks who maybe are not used to being in the political target in the same way that abortion providers have gotten used to being in.
Great answer.
Not much down. I think that was a phenomenal answer. I mean, I will say, I think one of the exceptions on places that link reproductive care and gender affirming care is Planned Parenthood, the largest single provider of gender affirming care in the state of Illinois outside of Chicago. So
Great plug, great plug.
The one thing to build off of is, because I think Amari is absolutely right about the difference between what is often framed and human experience as a point in time care versus continuum of care, is how that impacts associations and association rights. So, you know, we're looking at, particularly for, you know, a lot of the laws in this country have been targeting not pregnant people, but the people helping them.
Right.
Care. I think gender care, think about particularly parents and families who are working through young years. And when we hear a lot of the refugees on the care side, we don't just hear from trained. I mean, we have some heartbreaking stories of people fleeing Texas, looking for jobs in Illinois, having to get homes because they're so worried just about their kids, but that they need criminal in jail. And I think thinking through how that associated with risks and rights is also
Really, really, really great topics that everybody brought up. A couple of things that I want to add is, you know, although this is not always the case, when it comes to gender affirming care, it's typically ongoing, which I think could be a key difference. And I know that it does provide challenges for those institutions such as Planned Parenthood that are providing it, meaning, you know, there are funds, grants, networks to help people get across to Illinois to help them, you know, with perhaps an abortion or any other type of care. But it's not necessarily something that's going to be ongoing for years, although it could, it isn't typically. I think that's a big challenge because, you know, then that means where is it funded? Who's helping, you know? And the other thing is too, that I think is a pretty big difference for me, at least when I think about it, is, you know, if you include trans rights, it's not just healthcare. So now we're into an entirely new sphere of, you know, everyday life. And unfortunately, as we know, that's been under attack quite a bit, and we'll get there. But yes, otherwise, as far as, I do think that there are more similarities, I want to say that, than there are differences. But I just think it's interesting to point out those differences. So since we talked about Illinois, what about the legal landscape nationwide? And if I told you all how much research I did before this panel, just to make sure I was up to date. But anyway, because it changes so quickly. But yeah.
And I was liking the thing where Amari goes with the smart answer.
I can go first, but I was going to use the legal jargon of mishmash. So I don't know how helpful that is.
Well, I'll put, so again, I'm not a litigator and focus on anything, so I will just tell you what things look like here from policy advocacy space. So I think we have a couple of issues at play here. So, you know, one is the big question, and that the Shield law, I think that's part of this, which is what laws of other states have to be respected and enforced within the state. I think that is a huge issue, not simply around care and gender affirming care, but I do think that's a big constitutional question, whole faith and credit clause. Like this slippery slope there could be really scary. And I want to be clear, the shield law is absolutely the right policy position, the right legal position, the right moral position. And I think we have to be wide open to the idea that this bigger question about what laws other states are going to in turn out enforce and something we have to think about. I think that's a big issue.
Yeah, on the national landscape. So what the Dobbs decision did was embolden legislators across the country they were already, ramping up with anti-LGBTQ bills, and the Dobbs decision just emboldened them to, open the door. I'm mixing a lot of words here, but open the door and just introduce a whole and pass a whole host of bills. So nearly half the states have some sort of ban or regulation of gender affirming care of some type. Some of them are in litigation and they're being held off. The bills themselves and the laws that are being passed are also, it's very difficult to decipher. They take all different forms. Most of them pertain to minors, but they're written in a way that, maybe they're sweeping in people up to 21 or sometimes 26. We talked a little bit about this in the last panel, but there's a really huge chilling effect, a kind of misinformation effect of these really drastic bills getting introduced, and then people don't know, has it passed, what's going on, does it apply to adults, does it apply to helpers, who is getting caught up in this? So it's just a very, very difficult legal landscape. It's also, the litigation part of it makes it also difficult because a law might get passed and then a court might block it. It might go up on appeal and then be allowed to take effect. We just saw a ban in Indiana pertaining to gender affirming care take effect after court proceedings. So it just makes for just a very confusing, difficult legal landscape.
Agreed. Could not agree with that. Seriously, I could just put that on my refrigerator. That was perfect. It is so difficult to navigate it. And if it's difficult for us to navigate it, you imagine how difficult it is for those trying to seek the care. But one thing I really want to say really quickly is, as far as that legal landscape, another challenge, another thing that makes it difficult is the fact that, we do need to state that, and we'll get to it, but we do need to state that there have been a couple of moves towards trying to ban gender affirming care for adults. But the main attack has been on minors, and minors have limited rights. There's no other way to say it. I liken them to basically the way we used to treat or do treat child. It's somebody else has a legal right, or they're the only ones that can consent for them for any healthcare. And now there are some limitations to that in minor states. But the point though is that it's very difficult for them to stand up for themselves legally in some states. And I think that is also a big barrier to getting them, help. Now, there are amazing organizations such as ACLU that really do try to watch what state legislation and also courts are doing, but at the end of the day, there's only so many, people in ACLU even. So, but that is a huge challenge. But yeah, Can I just
upset to an issue matter. So one thing that we are finding a little bit through polling to Madam Joe, is often the issue of gender comes down exactly as you established the minors, and quite honestly, it comes down to social commerce, which we
yes,
very but what's interesting is what we have found to be effective is when you broaden in help and help people understand we are just talking about the issue of care, usually for emerging teens and teens, right? We know that this is not something that just comes up in gender affirming care. It comes up in not just abortion care, but reproductive freedom. It comes up in vaccine access.
Absolutely.
Right. So one of the things we just try to remind people is like we are just talking about health. Right. This is a big question about how much teens, in particular, emerging teens, should have access to medically accurate, affirming healthcare. That's the question. Whether it's vaccines, whether it's reproductive care, whether it's abortion care, whether it's gender affirming care. That's the question that we're asking. We try to honor how gender affirming care manifests differently, and that is important. But helping people realize that it's not like there's this thing called healthcare, and then there's this thing called gender affirming care.
Right. Right.
It's part of the bigger question about, how much a young person should get to decide with the in consultation with a licensed medical provider providing medically accurate, well-documented research care, what care they should. And we know how to wrestle with that in cases like vaccines and reproductive care. It's the same set of questions. Most.
Absolutely. I just want to say one thing to your point about licensed medical providers, etc. Nobody is trying to force providers to provide something that they are not, it's not within their scope of practice, or that they're not obviously feel like they are able to do. That would be a violation of their oath many times. But at the end of the day, it's about being able to access the correct information without it being skewed, without it being tainted, if you will, and also without it being, full of lies and disinformation. And unfortunately, that is not the case everywhere, obviously, and it's not even something that, if you go to a provider, a lot of times you're going to trust whatever that provider tells you. And if they are biased in any way, and we know that healthcare has bias, that's just a given, then it's going to have some huge effects on young people, or anyone, but especially young people. Did I steal your thunder? You want to say something? Okay. So basically, yes, there is a quilt of many colors, a huge patchwork, however you want to say, of the legal landscape, and it is very tumultuous. That I do see hope every once in a while. There are some good things happening. There are also, such as, it's so easy to take a shot at Indiana, but I'm going to do it. Then there's also, unfortunately, what happened in Indiana, the law that they passed, the ACLU was right at the forefront of that, trying to get the governor not to sign it, etc. But, Illinois continues to be one of the only, safe haven states, if you will, in the Midwest. And I don't think that that's going to go away anytime soon. But it also means that, unfortunately, our neighbors are more and more in a situation that is great. But something we were just talking about with dogs, I would like to propose, and I'd like to know if you all agree or disagree. Please, by all means, tell me truly what you think. I think that dogs is one of the key cases and key moments where people decided to start getting way more involved in their in other people's health in their business whenever they would have, basically trying to interject themselves between their doctor and themselves. I don't think that was ever as prevalent because the states couldn't do what they wanted to do until after Dobbs. But it really does seem like, as you said, after Dobbs, it just really ramped up. And I think that now people are emboldened to think that they have an opinion about other people's healthcare. Thoughts?
I think Dobbs certainly opens the door to this, and just, I guess, to set the table with a little law 101. The right to abortion that was recognized in Roe and in Planned Parenthood versus Casey was recognized in the Due Process Clause of the 14th Amendment, the right to privacy. And so when Dobbs said, well, to assess that, we're going to look back at history and tradition, then you're gonna start looking at all the rights that people had with this lens of, you know, purported history and tradition, as viewed by Justice Alito. And that's, you know, that's what's gonna open the door for all of these rights. And Justice Thomas, you know, Justice Alito in the opinion said, we're only talking about abortion in this case. But Justice Thomas in his current opinion in Dobbs really laid out an invitation to reconsider all these other rights. As Brian said, you know, Roe followed from Griswold about contraception, and the cases that followed from Roe in the same right to privacy have, you know, are the LGBTQ rights cases. And so the kind of doctrinally, when Dobbs came out, that really does put all of these other things in question. And, you know, Dobbs said it was leaving abortion to the states. So that just, you know, all of these lawmakers in all of these states took it as an invitation.
Yeah, I think I'm ambivalent about that framing, Tavish. I think in part because the architects and the biggest champions of the effort to take down Roe and Dobbs, that has always been there.
Yeah, that's a good point.
Right? I mean, I just remember Ken Paxton, the Attorney General of Texas, once Dobbs said that he would begin, as I'm all through on this, efforts to recriminalize homosexuality. Right? So that has always been their intent. I think the question is, I think the less intensely involved kind of coalition around it. I think some of them took it at face value that was all. We were just going to leave it to the states. And the architects of the movement, that was never their plan. We're looking at potential federal bans passed through Congress on abortion. Like we are, you know, I worry about, you know, in an unfriendly administration, things like the rescinding of federal funding for schools that teach LGBTQ plus inclusive curriculum, right? The denial of funding for federal funds for hospitals who provide abortion care,
Like the OC.
right? Just the realm of attacks I think have happened, and not even through legislation and courts, but just through funding. So I think while many people who were in favor of the Dobbs decision may not have, that might not have been an organizing principle. The people who brought Dobbs and funded the bringing of Dobbs and are funding the elected officials who are trying to manifest, you know, an anti-abortion care and anti-genital care a landscape in their states, like that has always been
Good. That was actually a really great way to make sure that you hone in on the issue. So it's not necessarily that, I mean, obviously we're not ever going to just stop with, you know, God no. And to be fair, they found a formula that works, a formula that they're continuing to use, gender affirming care and others, unfortunately. But the thing that I want to say is, to your point, it is about the way in which they are able to convince people in some states that, you know, that people need to be involved in other people's healthcare, that I think I meant more so. But you're right, the architects themselves absolutely were never going to stop. Very, very good point. So one of the things that actually goes right in, oh my God, it's like I did this on purpose. Let's talk about some of the tactics that they are using. So I will start. One of the things that I have been studying for several years now is this idea of using fear, which is nothing new, but in particular, when it comes to reproductive rights and gender affirming care, there is a very common fear tactic, and that is using the most young and most vulnerable. So, you know, it's never a fetus, it's a baby. There's a reason for that. It's never, you know, a 16, 17-year-old. It's always kind of viewed as somebody that's 6 years old, 5 years old, that's going to get surgery or something else that's absolutely absurd. So that's one tactic that I've noticed, but I'm wondering if anybody else has noticed any other tactics.
I agree with that. I think the fear and the misinformation, and in the area, somebody who spends a lot of time giving conversations, which is regular people around reproductive rights, gender affirming care, abortion. You know, I think in general, there's a lot greater need for public education with respect to gender affirming care. I think the conversation is not as far along, and so that contributes to people picking up on the misinformation and falling into the trap of, you know, kind of hearing these stories and believing them.
Yeah, and I think it's always dangerous to think out loud. But you know, I see it coming down to maybe two different camps. I think, you know, one camp is this showing of well-meaning concern, right? Which actually is just like there's a lot of data about abortion care, particularly the safety of medical abortions. There's a lot of information about gender-affirming care, but most people aren't abortion care providers or endocrinologists or have gone to law school. And so there's this like, you know, that might be the case, that might not be the case, but gosh, this just seems really good. I think we should just hold off on that until there's more. So I think there's the well-meaning uncertainty. I think the other thing is the fear for your for kids and for your kids, right? Like that they're going like, if you have a gender neutral restroom, can you imagine? And let me tell you, this is not about gender care, but I will just tell you, we passed a bill last year that said that any public accommodation business that wanted to have a gender neutral multiple stall restroom could do so, right? And this was a pro business bill because we know the other side does not like to put additional regulations on businesses. Surprise, they were opposed to it, but there was a senator on the floor of the Senate who threatened violence to any male person who's in the restroom at the same time, right? And so there's this fear that like we're going, that the provision of gender care, that LGBTQ plus rights, that facilities that people are allowed to use is going to strike fear and safety dangers. It is I think something else. The final thing I want to say though is because the architects, again, not the people who are persuaded by it, the architects of the fear argument, the architects of the arguments about well-meaning, misinformed uncertainty. When push comes to shove, really lean into cruelty.
Yes.
And what we have seen both polling and actual is when most citizens and most residents and most voters see that the other side is really just being cruel to people who need high quality education, cruel to people, young trans kids, when they're just being cruel. Most voters are like, look, I don't know exactly what I feel about these issues. I'm not that informed, but I don't want to be cruel like that.
Very true. Wow, that was extremely well said. Thank you. You know, I want to open this up to questions for everybody very soon. But I just want to say what an honor it is to sit on this panel with you. And thank you so much for this amazing conversation. I appreciate it. If anybody has, or actually, I'll just let Julie take over. I don't know what I'm doing. Go ahead.
Oh, no, you're good. We want to ask for more question about what inside.
So during the last panel, my organization, new HIPAA rules going to affect tech providers, like either requesting privacy from appreciate that. And I heard that in the kind of expected it sure we got to take a portion that anyway about gender care. How do we get through the thinking that it's just about abortion and get people understand always think that it's not just about giving people access to healthcare, to abortion in state, but also gender affirming and other things. How do we divide this?
I don't think this is so. I would just say, I think two things. So one is just reinforcing this argument that we made so forcefully, that Ameri and the ACLU of Illinois made so forcefully after Dobbs. It is not that these things are leading to, it's that they rest on these things, right? So they're exactly like, if you take away gender affirming, you take away the rights to gender affirming care, abortion care is not part of it, right? If you take away the rights to gender affirming care, there's a pathway to start coming after employment discrimination or non-discrimination protections, marriage equality, parental rights for your parents. Like, it is absolutely rests on the same foundation in the legal 101. I think the other thing, look, we say this in Illinois, and I'm not an expert, right? But I do think this is largely the case, which is, I can tell you, in the past 8 years, nobody has lost their seat in the Illinois General Assembly because of their vote supporting LGBTQ plus equality or reproductive freedom. Nobody. I can't say that nationwide, but I can say for our political leaders, the fear that they will lose their access to power is far greater than what data has shown us about.
I think to get to Brian's earlier point, I think the cruelty of a lot of this is becoming more apparent to people, and as I think we continue to see that, that's going to play a factor as well.
Agreed on both of those fronts. There's definitely no silver bullet. However, that doesn't mean that, advocating where you can, and also holding, the executive branch of our government, highest government, accountable, like Republicans did whenever he talked about Trans Day on Easter, apparently. But my point is that it is very, very important that we catch things like you just did with HIPAA. It's important to stay informed and also make sure that you get very correct information. Remember that media can be biased. That does not mean that all media is bad, but just make sure that you are checking your facts.
Thank you so much. I know the rough contours, I don't.
Know that it's gone into effect.
Yeah, they lost to the 7th Circuit. So the only recourse from there is the Supreme Court. So they're kind of, the legal appeals have run their course, unless the Supreme Court were to intervene and overturn the ban, which is not happening likely. But I only also think processes of the Indian ban.
No minors. Yes.
So looking forward to the future, right? We know where we're now. What will happen with that? What's coming? What are you advocating for? What are we looking at? And what are we mobilizing?
I'm going to talk about a big thing. We have a couple things running this cycle, which I think are important. I know the ACLU is really important, health data privacy, but let me just kind of wet the whistle here when we talk about the connected. We have been working for a couple of years with a coalition of former sex workers, mostly Black and trans sex workers, and we want to make Illinois the first state in the country to fully decriminalize adult consensual sex work. The reason that I is, look, it's very dangerous work because it exists outside protections and traditional, right? 75% of all people who engage in adult consensual sex work experience sexual assault and violence, and 2/3 of all trans people killed in the last decade of sex workers. There is no way to protect people engaged in adult consensual sex work unless we put it. I will also say, if we learned nothing from docs. It is the fact that we have to continue to accelerate the push to fully decriminalize adult consensual sex. Because so long as the state can criminalize any two adults engaging in consensual sex, again, like my marriage isn't safe, gender affirming care isn't safe, freedom isn't safe. We have to believe that two adults who want to consent and sex together should not have to experience the threat of harassment, police, prosecution, incarceration.
We have two measures at the ACLU that are proceeding through Springfield right now because we are in legislative session. One is to protect data privacy broadly around reproductive health care and gender care. So all of the information that your phone collects, that Google collects, all of that, and protect it from disclosure. So that is one measure. We are also working on a bill that enhances some protections around family law and custody arrangements for parents who are assisting their children with getting their minors with getting gender affirming care to just tighten things up a little bit around the edges there. So that's also proceeding in Springfield. On our litigation front, we've done a lot of work and continue to do a lot of work in the area of employment discrimination. We just settled a lawsuit against the city of Springfield because their municipal insurance plan didn't cover gender affirming care, so that just settled, and that will send a message. A lot of government entities and municipalities have insurance plans that are outside what the state can regulate and don't cover gender affirming care. So that's been a really positive development. And then we continue to do our work in litigation with people in custody. So we just resolved a lawsuit on behalf of a trans prisoner who's in federal prison, and we have an ongoing lawsuit against the State Department of Corrections for healthcare for trans prisoners in the State Department of Corrections. So those are going to be continuing. The other thing I always mention is the role of religion in all of this, and I want to mention it because Illinois has a very broad healthcare right of conscience act that allows healthcare providers to not provide care because of their religious beliefs or their conscience objections. And we amended the law a couple years ago so that people are not getting care because their doctor or their healthcare provider is invoking this law. They at least get some information about what is going on with them and their treatment and where they can go get that care.
What's the post to get?
That law was challenged, and there was a 3-day bench trial last fall, and we are waiting on the results of that trial. But the role of religion weaves through a lot of the issues that we've talked about. The Supreme Court recognizes religious rights over other rights. Increasingly views religion as license to discriminate, but that is one that is close to home, involving an Illinois law. So we would expect to see a decision coming out of federal court in Rockford to hopefully give patients a little more protection.
So one of the most amazing things about my career so far has actually been 100% helping Planned Parenthood, navigate this storm of legal challenges, doing our best to, reduce the risk associated with our healthcare practices and everything. So one of the things that I know that we're doing is, we've partnered with Epic, if anybody knows what Epic is. And, we are a very unique healthcare system in our patient population. Epic has been very open and very receptive to our privacy concerns. So we've been really pushing, to ensure that, it's one thing to have these things in law, which it is the law, we are still, but it's also another thing to make sure that our technology is practicing it. And that is something that our legal team has been working on, myself being on a committee that actually deals with Epic. Whew, anyway, that's a lot. But also another thing is that, we have to stay on the offense. I will say this, General Counsel and I talk about this quite often. I research things all the time on a it might happen basis just to make sure that, where are we? And, and I cannot speak for those that are providing healthcare, as a healthcare provider. I mean, I know a couple of their initiatives, but for the legal department, our biggest, concern is always to ensure that the company, the organization has the least amount of risk because it's such an important organization for the state of Illinois and the Midwest.
In the abortion providers across state line, that is more difficult because of the
I don't, that's a really good question. You're hearing more about patients and their families traveling across lines. I have anecdote. First of all, I'm not seeing research on this, I should say, and I've not heard anecdotally providers moving across state lines. Obviously, a lot of licensing challenges. These are really good questions. I just don't know the answer to either.
I know that some of the abortion providers that have been relocating also provide gender-affirming care, and it is definitely on their radar. I don't know, big picture how many that is. One of the things that we did do with our legislation last year was to make it easier for licensed professionals to come to Illinois and get their, bring their license over and begin providing care as soon as possible. So that applies to reproductive health care and gender-affirming care as well. So that's not to help people doing that, but I don't know, other than a couple of instances, reproductive health care providers who also provide it. I don't know how much it's yet.
I have noted that. I'm going to look into that question because I find that very fascinating question. It's an angle that I've never really considered. But I unfortunately don't have any information or any empirical data.
We have a resident researcher.
I'm definitely going to look into that. There's got to be somebody out there.
I mean, related to that, I don't know, like telehealth is a role in aiding people access to through mail or something like that, thinking about increasing use of and support for the using remote care.
Again, not an attorney. What I will say is that providers have to be very careful about telehealth. It is an amazing tool. But if your patient is not in the state in which you are licensed, it's problematic. Now, the reason that there was a lot of
Broadly,
very broadly,
like
that's broadly. That is broadly. That's broadly. Thank you for that clarification. Yes, it's very important to know. The reason I bring this up though is that there was a lot of confusion that during the pandemic, there was a lot of telehealth across state lines and stuff like that. Had to do with certain laws that were enacted by states and by the federal government, allowing it because of the emergency situation. Those things have since, I think, in all states, but I know in most states, definitely Illinois and the federal government no longer in place. So yes, telehealth is amazing, but in a way, you have to think about it. Somebody would have to travel and still be in the state of Illinois for it to be an ethical treatment.
So I don't know, you may have seen the article that was in Washington Post a week or so ago. Some states, when they wrote their shield laws, they wrote them in a way that some abortion providers are reading them as protecting them if they provide telehealth to people in other states. That really turns on the different states' laws, and those laws are still untested. But as Tavish said, by and large, generally in the law, it's typically recognized that in terms of licensing and professional regulation that goes by the state where the patient is located when telehealth is being provided. So telehealth across state lines, except for during COVID, usually kind of within one state.
And I think just when we talk about health security, that is also other types of professional services, right? It's not just medical. So
Attorneys.
But I mean, this has been one of the difficult things in the post-doc landscape when we try to now that we have every state doing their own thing, and we try to think about how do you put your arms around Illinois and keep, you know, Missouri or Texas from reaching in here. You know, a lot of these things are state by state, but a lot of things we do are meant to bring down the walls and make it easier to go across state lines. So it's easy, you know, when I'm filing a lawsuit to go into another state with a subpoena and get it served without getting a lot of process. You know, we have people may have dual medical licenses in one state and another. So a lot of the challenge has been navigating where these lines are, where have they come down, where do we want to put them back up in kind of this new landscape where you want to protect the policy in your own state and make sure that it's dictated by your own state's laws.
I just happen to be the very first one. I just want to say that we didn't recognize that there are and we happen to be in one as it relates to them. There was a very limited number of providers and access right here in Champaign, Urbana, Illinois, which is thought of as this really one of the things. And the here, the husband is a massive provider, a gender provider, but you know, there are very few providers that are actually doing it. And so people are reaching to within the state, but we also know that people have to drive out to get care that has to be on board.
Yes.
And I think it's important to recognize the financial burden that and that, you know, there isn't a legislative solution to a financial burden, an education burden, at a time that is, and so I want to call that and recognize it as a massive.
Cool.
Awesome. To piggyback off of what you just said, just so you're aware, I know that there are certain organizations that are trying to lobby the curriculum of medical schools to include it more. I know that's not going to be a patch or fix anytime soon, but the fact that those conversations are happening at this point is pretty incredible, such as I think the CEO of American Medical Association has been advocating for a change in the curriculum at I almost said law school. Every time I want to say law school, medical school for a pretty good while now. But really good point, extremely good.
I just want to say, some students of a nearby medical school have reported to me that they get 1 hour of LGBTQ plus cultural competency in their entire education.
And I'm done.
I don't remember mine off the top of my head, but they're on the ACLU Illinois website.
I was going to say, I was joking. It takes me till May to remember our bill numbers. Yeah,
No,
so
this is the wild west of the legislative session too, where everything is moving really fast.
we did the same thing. So we're following the you go to our website and look at the legislative session. We have a host of our bills, not a lot, which is directly on health, which I've talked to them so much. The bills that we are meeting or co-meeting, as well as the bills that we are supporting, that's some of our champions.
Can I use both of those websites? Why? Yeah.
And if you sign up for action alerts with any of our organizations, we'll tell you when they're moving, we'll tell you when to call people.
No, we are not shy.
And then your witness slips.
Yeah.
And I but it was a talking about it. And those kinds of things, you know, kind of their not finding therapists that is like informed, like, you know, like, like first being informed and like I can provide interventions that are like helpful and
Right.
useful and resources and like what is it and priority list. Okay, like all these things are happening. So healthcare typically across the board in terms of parental health falls to the and yeah, care informs or what right?
I think what we did do, but Jill took it back, so we worked with broad coalition groups to make Illinois one of the only states in the country that requires all medical, so not just doctors, we're talking about therapists, we're talking about mental health providers, in order to renew your license, you have to have cultural competence. Now, we specifically made this broad. This took a couple of years because of the resistance of professional associations supporting that industry. But, you know, we wanted it to be broad so that providers could choose the cultural competency education that they needed, that most men needed, right? If they were serving a community that was increasing in immigration, if it was more queer people, more second language speakers, if it was more traditional religious minorities, they could choose the cultural competency that they needed to just about that. So it's a small fix, but that is what we think is like the beginning of saying you cannot provide accurate, appropriate healthcare of any kind unless you are meeting the needs of the diversified patients. So cultural competency is not like there's healthcare and then there's cultural competence. It is absolutely integrated. So one small fix, we're always still for ideas.
I know that there are some resources, but unfortunately, I hesitate only because I'm not sure if the one in particular I'm thinking about is just the Chicago area, which is a shame. And you know, as far as behavioral health, especially given the fact that I'm the director of behavioral health policy, it is something that I'm incredibly passionate about. It is something, as far as therapeutic services are concerned, that I'm really, really happy that we have more of a telehealth ability to meet that need, because it's extremely important. But to your point, there is definitely big, even within the Chicagoland area, I really want to make that clear. There's a very big, very huge behavioral health need, and especially I would say for LGBTQ plus people, for your community. So, you know, again, I agree, always open to suggestions, and also, you know, maybe the university, I have no idea, some resources, but unfortunately,
So you've already said a few of them, I just want you to follow these. We learned a lot today. We talked about what can people do when they need this? What actions should people be taking in their personal lives, lives?
I'll say 3. So sign up for action alerts, action alerts, action alerts. Make sure you're on all of our lists. Not just for your action, but will help. I would say the other thing, maybe I'll just go. I'd say the other thing is, obviously, with the care, I just want to say, if there's anything to support the organizations, community or process that have trans and gender non-binary on boards and leadership teams of organizations, right? If you can make donations, if you can volunteer, I think that is really, really critical to make sure that we are investing in the capacity and support of organizations led.
I said this on the last panel, but I'm going to say it again, even though nobody wants to hear it once, let alone twice. But, you know, you do need to vote, and especially in the local races, a lot of the, you know, attacks on libraries and fans of things that happen in school. Very few people turn out for those elections, and your vote really matters. It matters up and down the ballot, but, you know, a lot of these attacks happen very low.
Okay, if I can build on it, it is very rare that somebody gets elected to the US Congress or to the US Senate without having served elected office first.
Yeah.
So not only does it impact the act today, but we need to cut off the pipeline of the anti-freedom, anti-equality, homophobes and transphobes that are trying to build their base or increase their leadership. And one of the great ways to do that is to keep them off the local
And I'm going to add one more thing. In the last panel, I talked about what happened in Danville. I'm going to talk about what happened in Quincy when they tried to pass a sanctuary city for the outbreak ordinance, because that got voted down outright. But it got voted down after one community member and a couple of other folks got wind that this was trying to be passed in Quincy. There was some shenanigans of putting it on the agenda, and she stayed on it. She called us. She called everybody. She got her community organized. She got people to turn out and vote it down. So keeping your eyes and ears open, and do not underestimate what one person can do in their own community.
And I just learned that both mishmash and shenanigans are real. Next one's going to be a fruit pop.
I'm from the Midwest.
By the way, use y'all. I haven't looked in for your brother lately. Because I use y'all on myself. So here's the thing. I am going to build off what you just said. One person to the gentle person who mentioned that looking up HIPAA. That's a really good start. Keep yourself informed. When you're told something by panels of experts, even experts make, mistakes. Check your facts. Stay informed. And then the other thing is, in my opinion, I would state that, make sure that you are, not only supporting places that have LGBTQ plus people in position of power or, represent, but also make sure that you think about your own personal, does your work have any type of protections or any discussion in the personnel manual about trans rights, about trans people, about DE&I, about LGBTQ plus, does your work celebrate Pride? I mean, little things like that. That doesn't really seem like that's that big of a deal, but trust me, it's a big, big deal. Now I understand also not everybody works in a non-hostile situation, but that's just one example of trying to influence your personal spirit. I think that we can all agree that the only person we really are responsible for is ourselves. So.
Thank you both.
I'm an example of a community member who needed to take action and made Urbana-Champaign Reproductive Justice real. We are grassroots, we are volunteer-led. I always am excited to connect with you at your workplaces, you people. So please come see me, email me, let me know what I can do to help boost the work that you're doing. Because speaking these things out loud and without stigma is a huge, it's very, very important for all of us individuals. We are raising money this week for Elevated Access and Midwest Access Coalition, so I invite you to donate there. And I invite you to all of the events through the rest of the week, including our Party for Reproductive Justice at the Rose Bowl at the end of the week, where we have some amazing local musicians, some guests, and a lot of fun. So thank you so much for coming here and being here, and
Thank you, Julie. Thank you, everyone.
So good to see you.